From the News Channel 5 Network, this is OpenLine.
Hello, everyone. Welcome to OpenLine. Glad you're with us tonight. We are talking about Roe versus Wade, but we are looking at the history of Roe versus Wade, not trying to have people debate the merits and raise their temperatures as much as that is possible with this. We don't want that to be the case. What we want to do is look back at the history of this issue. How did we get here? What might it mean if this is overturned? What is it that Samuel Alito is saying in his leaked opinion? And what might we hear from the other side, the dissenters in this opinion? So plenty to discuss. Happy to have with us Dr. John Weil, political science professor at MTSU, joining us via Zoom. Dr. Weil, thank you so much for being here.
It's a pleasure to be here.
So let's say this opinion, how soon could this opinion come out, and what would happen when it does come out, if it remains intact? How soon could we see this actually happen?
I mean, theoretically, I suppose it could come out any day. It's most likely to come out toward the end of June. Typically, the Supreme Court will save its most consequential cases right to the end of the term, and that's usually when it is. The effect, if the decision remains, and it's important to note that in the Casey decision, which had reaffirmed Roe 20 years before, apparently there was an initial majority to overturn Roe, and then at least one of the justices switched to the other side, and so they ended up affirming it. So it's not absolutely certain that it will come about, but if it does, it will likely vary in terms of consequences depending on the state. Many states, including Tennessee, I believe, have trigger laws, which would automatically put back in place either pre-Roe versus Wade laws or laws that have been adopted subsequently to restrict abortion. And in some states, it might be at the end of 15 weeks. In another, it might be 20. But, prior to Roe, there was actually a fairly strong movement, particularly in states like California and New York, to liberalize abortion. So in some states, Roe versus Wade probably didn't make much difference. Where it did make a difference was particularly, I would think, in the southern states were probably, more likely to have strong anti-abortion laws than others.
There are a lot of states with those trigger laws. Tennessee is one of them, and I think in Tennessee it's 30 days after abortion is banned, then that would take effect here, I believe, and that's what it is in some states. You would pretty quickly have a situation where there would be a bunch of states where abortion is legal and a bunch of states where it's illegal, right? We would have a patchwork in this country of abortion.
Which essentially is what we had before Roe versus Wade. And one of the arguments actually for a Supreme Court decision was some people said, it doesn't seem fair that, if we're under the same Constitution, shouldn't we have similar rules? On the other hand, we have a federal system, and issues involving marriage and family have typically been legislated at the state level.
A couple of things. You said there was that other decision, Casey, where you said it's likely that a Supreme Court justice changed their mind.
Right.
We've never had a leak like this. This has never happened. No. And so how does that change things? How unlikely is it, do you think, that one of these justices could change their mind in the wake of this leak?
Well, let me just put a little caveat here. There have been past decisions where the actual outcome has been leaked in advance. And this actually occurred right before James Buchanan was elected president or became president in 1857. Not that I personally remember it, but nonetheless, he had gotten word that the Supreme Court had come to a decision. And in his inaugural address, if I recall, he basically said, just wait a week or two and the Supreme Court's going to solve all of this. And there were many people who thought that was the case with Roe versus Wade. You know, the Supreme Court will decide, people will say, well, the court has ruled, that's it. But it almost seems to have stirred more passion than maybe would have occurred if we had just continued on a state-by-state path.
So you're saying that's very interesting. If the 1973 decision, Roe versus Wade, you think it may have stirred more passion than if we had just stayed on the path?
I think so. I mean, again, we're sort of, you know, trying to imagine what would have happened, but I believe none other than Ruth Bader Ginsburg had suggested that that decision sort of short-circuited the political process. And, you know, I'm a strong advocate of 3 branches of government and an independent judiciary, but it's not an elected branch. And there is sometimes a better course of wisdom for the court is to say not necessarily never, but not today. Or, you know, not Chief Justice, but Justice Louis Brandeis was often referred to states as laboratories of democracy. And we will go back probably if this decision stands, and I think it's likely to stand. I don't know if I answered that earlier. I mean, it's not it has happened in cases we know where people have made a decision from one to the other. But what's interesting is that the decision is actually dated in February, which suggests that it's been out there for, you know, almost 3 months now.
Oh, right.
And
yeah.
You would think, although I'm not saying this for sure, but that if the court had subsequently changed its mind, that Roberts might simply have said, you know, yes, this was an opinion, but we're not there, you know, we're not necessarily there now, to sort of prepare the public. And he didn't take that approach, and apparently he is in the minority.
That's a good point. And so it could be that these 5 justices side with Alito. Then you would have a dissenting opinion, presumably, I guess, with 3 or 4 justices, depending on how Roberts goes. And it could be that they each write their own opinion. Is that an accurate statement? We could have, like, Roberts could write his own opinion.
Yes. I mean, and you could even have, sometimes you'll get, reading court decisions can be like reading tea leaves. Sometimes they'll say, well, I agree with points 1 and 2, you know, Roman numerals 1 and 2, but I dissent from Roman numeral 3. And so you could have some partial, you know, Roberts might say something like, I've never been a fan of the reasoning in Roe versus Wade, but I would give greater attention to precedent than, you know, my colleague Alito. And I suspect that you'll have some fairly passionate dissents on the part of, you know, particularly the 2 other women on the court.
Now, Alito writes, Roe was egregiously wrong from the start. We hold that Roe and Casey must be overruled. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. What do you unpack with all that? What do you think that means?
Well, conservatives, Alito among them, are typically strong federalists in the sense of supporting state determination of matters that have traditionally been in state hands. And he does. I mean, he pretty much takes an axe to the reasoning in Roe versus Wade. He says it reads more like an act of legislation than it does interpretation of the Constitution. He points out that the Constitution doesn't mention abortion, it doesn't mention trimesters, it doesn't mention viability, and and probably most interesting of all, he claims that it got the history wrong. Roe versus Wade had essentially said that in 1868, most states had permitted abortion. And he has, if you read the opinion, it's 98 pages. At the end of it, he has a list of 30 states and another 5 or 10 territories, in most of whom had adopted legislation against abortion prior to 1868. And unfortunately, I have not had time to go through and compare the reasoning in Roe and I mean the history in Roe and the history of this. But he seems fairly convinced that the original court, you know, was based on faulty historical analysis.
Yeah, the history is so important here. Both sides are saying Well, throughout history, it was their side, and
Yes.
I guess they can't both be right, or maybe they can both be right if you pull certain parts. But both are
Sure.
saying history was on their side, that abortion was legal for a long time, or that abortion was not legal for a long time. Is that right?
That is, and of course, part of it is that the medical, and Blackman in the Roe decision made a point of saying that he thought that the laws that were adopted toward the end of the 19th century had more to do with protecting the health of the woman than it did protecting the child, because he pointed out, prior to antiseptics, abortion was much more dangerous to the woman than it is now. So he tried to weigh, the interest of the woman against the interest of the fetus. Interestingly, at the time, his decision didn't really please either side. Those who favored abortion thought that he didn't go far enough, and those opposed it, of course, said, when you've opened up the floodgates.
The 1973 decision found a constitutional right to abortion grounded in what is described as a right to privacy provided in the 14th Amendment. So it's the right to privacy, is that correct? And it's the 14th Amendment that are the reasons for this decision that I guess Alito is saying is egregiously wrong.
Right. I mean, now there had been a prior decision. Well, there have been several, but the most relevant prior decision was a 1965 case called Griswold versus Connecticut, and it involved whether a state could prohibit married couples from using contraception. And in that decision, which was written by Justice William O. Douglas, a Wild Bill, as one of my friends referred to him in a biography, he said he tried to construct a right to privacy by saying, well, the Constitution doesn't mention it, but First Amendment talks about a right to association. The Third Amendment talks about people not being stationed in your house. The 14th Amendment prohibits searches and seizures. The Fifth Amendment gives you a right of self-incrimination. And if you throw in the Ninth Amendment, which talks about unenumerated rights, there's a right of privacy. And then Roe sort of built in part on, or large part, on that decision.
So, I mean, now I'm a little off topic here, but you're saying in 1965, contraception was illegal? That there was a thought that you could not...
well...
What about that?
Right. Let me qualify. Not to the extent that abortion would have been, but there was, if I recall, Connecticut, which was a fairly, Griswold versus Connecticut. Connecticut was a fairly predominantly Roman Catholic state, and the legislators had legislated, I suppose you would say, at least official Catholic doctrine pretty much into law. And so it was illegal to buy, say, condoms or use birth control devices, birth control pills, and the like. I don't think it had been very frequently enforced, but it was enforced against Griswold, and the case got to the court, and they overturned the conviction. And
that's part of what people are concerned about here. At least that's what some people are saying, that if it is overturned, it would jeopardize other rights the courts have said are the result of privacy, such as the right to contraception or to engage in private consensual sexual activity, to marry someone of the same sex. Is that right? What about that whole...
Well, it partly depends on whether... It depends on whether Alito's view is that it continues to be the view of the court. Alito says there's something different about abortion, namely you're interfering with potential life, is the term that the court had previously been used. And he says that's not the case. The three main areas that have been talked about have been contraception, interracial marriage, which was the court accepted in a 1967 case, I believe it was, Loving versus Virginia, and then also the Obergefell, I have trouble pronouncing it, the decision in which the Supreme Court recently, or within the last 7 or 8 years, legalized gay marriage. But Alito specifically says these cases are different. They don't involve another life. And in the case of gay marriage, he specifically says they don't, he says, traditional cases that we have not overturned have dealt either with contract law or with property. So, for example, if you get married, you enter into a covenant or a contract, you often share possessions and that sort of thing. And he says those cases are different than the kind of legislation you have for or against abortion. And he says at one point specifically, no one, and he claims to be speaking for the 5 of them, he says no one should interpret this case as an invitation to relitigate these other areas. I think that it'll still be litigated, but I think that Alito's, the opinion is fairly strong in terms of what he and apparently the majority think.
There's no doubt he is saying that. Yeah, this shouldn't cast doubt. We don't want to overturn anything but abortion. Abortion is what we're focused on. But when you look at some of the reasons why it's being overturned and saying it's time to heed the Constitution and return the issue of abortion to the people's elected representatives, I mean, what is to say they wouldn't say later, well, there's nothing protecting some of these other things in the Constitution. We should let the people's elected representatives decide those things.
Right. And another major argument in this case is he argues that historically there has not been a long tradition, according to him, of protecting the right of abortion. Well, this would also be true of same-sex marriage, would it not? I mean, in American law, it wasn't until maybe 20 years ago that, a court here or there, made a decision often on the basis of their state constitution. So that might give pause to some people. Again, I think particularly for those that have already entered into such an arrangement, I can't imagine the court backing down, but stranger things have happened.
Very interesting. Okay, so that kind of sets the table for our discussion. We're looking at the history and maybe where do we go? Where do we go from here? Should this become law? So we'll take a break, come back, continue our discussion. If you want to call in with a question or thought, there's the number, 615-737-PLUS, 615-737-7587. We'll take a break. Be back right after this.